Hi, I'm Denise, and you're watching Law with Denise. This is a case summary of McLoughlin and O'Brien and others, 1983. In this video, you will learn the facts of the case, the arguments put forward by the plaintiff and the defendants, and the decisions reached at first instance, in the Court of Appeal, and in the House of Lords. So who are the plaintiffs and defendants in McLoughlin and O'Brien and others, 1983? Our plaintiff was Mrs. McLoughlin, whose family was involved in a road accident with our first defendant, O'Brien. And who were the defendants? There were four defendants in this case. The first was O'Brien, the lorry driver who collided with Mrs. McLoughlin's family in the road accident. The second defendant was the owner of O'Brien's lorry that he was driving when he collided with the family. And they were A.E. Docker and Sons Limited. Our third defendant was Raymond Sygrove. Raymond Sygrove was also a lorry driver, and his lorry had collided with O'Brien's lorry before O'Brien had an accident with Mrs. McLoughlin's family. Our fourth defendant was Ernest Doe and Sons Limited, and this company owned the lorry that Raymond Sygrove was driving. So there we have four defendants and one plaintiff, Mrs. McLoughlin. Now, what are the facts of this case? There was a road accident between O'Brien, the first defendant, and the plaintiff's family, so Mrs. McLoughlin's family. This accident occurred on October 19th, 1973, and it occurred at about 4 p.m. Now, Mrs. McLoughlin was not in the vehicle when the accident occurred. In fact, Mrs. McLoughlin was at home, and her home was around 2 miles away from where the accident occurred. She would be told about the accident by a neighbor and friend, a Mr. Pilgrim, and should be told about it around 2 hours after it occurred. She then went to the hospital where her family was, and she saw them at around 6 p.m. So around 2 hours after, approximately, she saw her family. Now, what Mrs. McLoughlin saw and heard, she argued, led to her developing psychiatric injuries. The psychiatric injuries that Mrs. McLoughlin developed were depression and a personality change. Now, what exactly did Mrs. McLoughlin see and hear? Mrs. McLoughlin saw that her family was terribly injured. She saw that her husband was in severe shock and he had bruises over his body. She heard her son scream, and she saw her son, George, not only in physical harm, but she saw him lapse into unconsciousness. And George had actually suffered a concoction. Kathleen, one of her daughters that was in the vehicle at the time, also suffered injuries and a concoction. So she heard the screams and the cries, and she saw her family in this distress. Mrs. McLoughlin also learned that her younger daughter, who was nearly 3 at the time, had actually died in the road accident. So these are all the sufferings that Mrs. McLoughlin endured on that day. 3 years later, she started a case. And she started a case against the four defendants named at the beginning of the video. Her argument was that she had suffered psychiatric injuries because of what she saw and heard, and she claimed that the defendants were liable for these injuries because it was the negligence of both O'Brien and Raymond Sygrove which led to the accident, which led to the injuries of her family and the death of her younger daughter, which then caused her to suffer the psychiatric injuries that she suffered. Now, the defendants argued that they could see, and they agreed that they were liable for the death of her younger daughter and the injuries to her other family members. But they argued that they were not liable for the injuries to Mrs. McLoughlin. And what happened at first instance? At first instance, Justice Borham, the judge dealing with the case, did not agree with Mrs. McLoughlin. He argued, or he decided rather, that injury to Mrs. McLoughlin was not reasonably foreseeable. So Mrs. McLoughlin lost her case. But Mrs. McLoughlin did appeal, and this appeal went on to the Court of Appeal. Now, before I discuss what happened in the Court of Appeal, I do want to let you know that if you are looking for other videos related to psychiatric injury in English tort law, I have several videos with case summaries and discussions of different cases such as Borhill and Young, Alcock and Chief Constable South Yorkshire, and White and Chief Constable South Yorkshire. The links to these videos are in the description. You may also be looking for videos which explain negligence and duty of care. I have a playlist with videos which relate to this topic as well. So have a look in the description for relevant links. The Lord Justices decided the following. They thought that injury to Mrs. McLoughlin was reasonably foreseeable. However, Mrs. McLoughlin still was not able to recover damages in the Court of Appeal. And why not? Well, the Lord Justices made clear that even though injury to Mrs. McLoughlin was reasonably foreseeable, the law did not permit for people in her position to recover damages. They said no duty of care was owed to people such as Mrs. McLoughlin because Mrs. McLoughlin was not directly affected by the negligence of the drivers, nor was she at or near the scene of the accident when it occurred. Remember, Mrs. McLoughlin was 2 miles away from the accident, and she did not see her family until 2 hours after the accident occurred. So these details, the Lord Justices said, prevented her from recovering damages. And the Lord Justices said that in order to allow her to recover damages, they would need to extend the law or develop the common law. But they could not do this, they claimed, because there were policy reasons which prevented them from doing it. So appeal dismissed. Mrs. McLoughlin made a further appeal, and this appeal went on to the House of Lords. What did the House of Lords decide? The House of Lords decided that injury to Mrs. McLoughlin was reasonably foreseeable, but they disagreed with the Court of Appeal with regard to their argument that policy reasons were preventing an extension or development of the law in this area. The House of Lords decided that it was impractical to always insist that a plaintiff had to demonstrate that they were at or near the scene of an accident before they could recover damages. The House of Lords said that they were willing to extend the law to allow for plaintiffs to sometimes recover damages when they came upon the aftermath of the accident, such as in Mrs. McLoughlin's case. So Mrs. McLoughlin was able to recover damages, even though she was not at or near the scene of the accident, but came upon its aftermath when she viewed her family in hospital 2 hours after the accident occurred. I hope that was useful. Until next time, take care and bye-bye.